everyone, welcome back. So last week we finished up with all of the police procedures. So this week we're going to move on and talk about all of the courtroom procedures. So we're moving away from police finally. We spent all this time talking about police. Now we're moving into courts. So hopefully you took your exam and got that done. And you're ready now to move on to court procedures. Excuse me. So let me share my screen. Hopefully you're seeing the first slide, the criminal justice system. So we're moving on to chapter 12. And in this chapter, we're going to talk about the different steps in the criminal justice process. So hopefully this is a review that you learned from your intro class, but we're going to go through each of the steps in the system. We're going to talk about them in more detail, and you're going to have to know some of the specific rules and procedures that govern each of these steps, okay? So in intro, you kind of got an overview of all the steps. Now we're going to look specifically at each step and some of the rules that govern those steps. So just as a review from the very beginning, we said that the criminal justice system is made of three parts. What are those three parts? Police, courts, and corrections. So we have now finished with all the policing stuff. So now it's time to move on to the courts things. So we're going to spend the rest of the semester talking about court procedures. Now, when we're talking about all of the steps in the criminal justice process, we can break them down into 5 main stages. Okay, so you have an investigative stage, you have a charging stage, you have a pre-trial stage, you have the actual trial, and then you have the post-trial stage. So we're going to put all of these steps into one of these stages. So you're going to see how the different stages are broken down. Okay, so we're going to start with the investigative stage. So the investigative stage is the part of the criminal justice system that completes the first step. So it's all of the steps that we talked about with policing, okay? So this is where we're trying to gather the evidence, make the arrest, do all those things to get the person and start them into the system. That's the investigative stage, okay? So all that we've learned already, police searches, seizures, arrests, questions, interrogations, pretrial identifications, those all occur in this investigative stage because those are all the steps that the police are taking in the system. Now, before any of this can get started, before you even move into the criminal justice system, something has to happen, right? Just average people aren't sucked into the criminal justice system. So what has to occur before you get sucked into the criminal justice system? You need a crime. Okay, so you always need a crime to occur in order to get somebody moving forward in the criminal justice system. Now, one thing I forgot to tell you is I have posted a document online, and it's a chart which is talking about the steps in the criminal justice process. So what I would suggest that you do is I would suggest that you print this out. Okay, so I'll show you what it looks like. Nope, that didn't work. Hold on, let me see. Try it this way. Okay, so if you go to Blackboard, you will see something that says like steps in the process or game board or something like that. You probably want to print that out because as we go through these steps, you'll be able to fill them in and then you'll have a great puzzle or piece that shows you all the steps and how they are all interrelated. So as I go through this PowerPoint, I'm going to use this chart and I'm going to be filling it in throughout the lecture. So if you don't want to print or you don't have a print, just draw it really quick on a piece of paper, and then you can kind of fill in the boxes where you need to, or you can open it on your computer and just, you know, type in the information that you need to in each of the boxes. Okay, but you definitely want to have this before you move on with the rest of the lecture. Okay. So we said the very first box was that you need to have a crime. Okay, so crime has to occur before you even get into the system. So if you have a crime, police get called or somehow the police find out about that crime. Now is the step where they have to gather the evidence of the crime. So we have to think about what is it called when police go to the crime scene, gather the evidence, and try to figure out who is the person that committed the crime. So this is called the investigation. So if you're filling out your chart, this will be the first square on the top left after the crime. You have the investigation. Okay, so what happens during this investigative part? All of the procedures that we've already talked about in the class. So searches and seizures and search warrants and all of that stuff is part of the investigative stage. Stop and questioning, possibly turning into arrests, frisks, all of those are going to be part of the investigative stage. Interrogations usually occurs during the interrogation phase, and then possible eyewitness identifications can occur during this this investigative stage. So what is happening are the police during this investigative stage are trying to gather all the evidence to prove each of the elements of the crime. And then they're going to eventually turn over this evidence to the prosecutor's office to use at trial to convict the defendant, okay? So all the procedures that we talked about so far with police procedures, those are all the steps in the investigation. Okay. So after they've gathered all of their evidence, which shows that a particular person committed the crime. So now we have a particular person, particular crime. We have probable cause. What do we do next? We've investigated, we've gathered all our evidence, we have probable cause, and we now want to be able to pull that person into custody. What is that step called? Well, that is called your arrest. So the arrest and custody, remember, are interchangeable. So once you have all of your evidence, all your ducks in a row, and you have enough evidence to prove that the person committed the crime, then you're going to get your arrest warrant and you're going to go to the judge and you're going to arrest. So what happens during the arrest? Well, we make sure that there is probable cause. We double check all of the evidence and make sure we have enough. We write it up on our arrest, our accusatory instrument where we're charging them with the crime, and we fill out that application. Then we take it to a judge, and the judge is going to double check to make sure that, yes, there is in fact probable cause. If the judge signs the arrest warrant, then we need to properly execute that warrant, and we need to use proper use of force in the arrest. So again, these are all things that we've already talked about in class. Now, once the person is arrested, they have to be taken back to the police station and they have to make an administrative record. What is the process of making that administrative record? That is booking. So we know that we need to create paperwork and keep a track of everything that happens. That occurs during this booking process. So fingerprints may be taken, mug shots may be taken. The arrest report is going to be written up for when they were arrested. You also may have some pretrial identifications at this stage. So all of these things have to be documented, and that's what the booking process is. It's an administrative record to create a paper trail of everything that happened. Now, those are all the police stages, okay? So those are all the steps that we've already talked about, and they occur during the police stage. But that only is a small portion of what happens in the criminal justice system. So we have to think about what happens next. So when the police arrest somebody, and so they get the arrest warrant, they arrest them, and they put them in jail, do they just sit there forever? What are some of the steps that we have to talk about now that occur after the police have already performed their steps? And so the question is, do they just sit in jail forever? And the answer is no. What happens is they have to be brought in front of a judge in a very quick amount of time, and they have to have what's called the initial or first appearance. Initial and first appearance are interchangeable words, okay? They both mean the same thing. So what the heck is happening during this initial appearance? Well, they're going to take the defendant to court. So we have the police arresting on what charges they think exist. but we need a check on the police. We need to make sure that there is actually enough evidence to keep moving forward. So you're going to bring the defendant to the court in this initial appearance. At this court hearing in front of a judge, the judge is going to read them the charges from the arrest warrant. So whatever the charges are that the police decided to arrest on, they are read to the defendant. The defendant is read their rights. So just to make sure that they were read their rights originally, the court's going to read them again in court where it can be recorded. They also are going to appoint counsel. So if you need an attorney, if you cannot afford one, remember, if you are too poor to afford an attorney, it's called indigency. So if you are indigent and too poor to afford an attorney, this is when they are going to appoint one. You may have what's called a Gerstein hearing, which we're going to talk in a minute. And then the other thing that's going to happen is they could be giving you what's called pre-trial release. Okay, so we'll get in a little more details about pre-trial release. So these are the main things that happen at this first or initial appearance. Now, remember, when you're first arrested in New York, you're always going to be brought to a city, town, or village court for this initial appearance. So it doesn't matter the charges or anything. If you're first arrested, they're going to bring you within a short amount of time to some sort of municipal court. Now, there are some rules governing this initial appearance. In New York, it has to occur fast. We don't want people just sitting around in jail and just waiting around. We want to have a check on police fairly quickly to make sure that there's enough evidence to keep moving forward. Under the federal rules, it just says without undue delay. So you have to try to do it as fast as you can. In New York, it has to be done within 24 to 36 hours. So you cannot be left sitting in jail for very long. You have to be in front of a judge very quickly. Now, sometimes in New York, they combined this initial appearance, which what we'll talk about is the arraignment. We're not going to learn it that way. We're going to learn each individual step separately. But just so if you don't get confused, sometimes the first time they're brought to the judge, they also do an arraignment. So we'll talk about that in a few minutes. So what if the police arrest someone without a warrant? So we went over certain circumstances where a police officer could arrest somebody without a warrant. Now, remember we said in a house, you should always have a warrant. But if you're out in public places, there are certain circumstances where you can arrest without a warrant. Or if there's an emergency situation, even in a home, you can arrest without a warrant. But we still need a check on police to make sure that probable cause existed. So remember, getting a warrant is just the judge reviewing to make sure probable cause actually exists. If you got arrested without a warrant, we still need to have that process where the police can be checked and assure that they had probable cause before they conducted the arrest. So if a defendant is arrested without a warrant, then they are entitled to what's called a Gerstein hearing. And this is a hearing that occurs after the arrest. And the whole purpose of it was to determine if the arrest was proper. Okay, so the court is going to review after the arrest whether probable cause did in fact exist at the time of the arrest. Okay, so if you do not have an arrest warrant, then this has to occur within 48 hours of the arrest. Again, it's a quick check on the system to assure that the police are not arresting people and holding them when there's really no probable cause to have arrested them in the first place. Okay, so a lot of times this occurs with the initial appearance, but it's specifically designed to see whether or not there was in fact probable cause when the arrest was conducted. Now, once you are arrested and you're taken to the judge for the preliminary or initial appearance, do you just get to, no matter what happens, turn on and walk out and go home? And the answer to that is no. The judge is given the option of what we call pre-trial releases. Okay, so the judge has to make a determination. Do we want to hold you until the trial occurs, or are we going to let you go and just expect you to return? So these decisions are what we call pre-trial release decisions. Now, when you're talking about pre-trial release, there are different options that the judge has. So they could trust you just to come back and no assurances, just your word. That's what we call release on your own recognizance. And sometimes it's shortened to ROR. So if the judge believes you'll just show back up to defend yourself, then they're going to release you on your own recognizance or give you ROR. Now, sometimes they'll release you, but you have to satisfy certain conditions. You may have to have an ankle bracelet, you may have to report, you may have to live a certain place or keep going to work. If the judge puts conditions on your release, then that's what's called a conditional release. Sometimes they may release you to a third party. So if you're a juvenile, they may allow you to go back with your family, but your family is responsible to assure that you come back. And the last one is what we call bail. So bail is when the judge or the court will make you give money, and that money will assure that you're going to come back. So it's not a punishment money. You're giving them money to assure that you'll come back so that when you do come back, they'll give you the money back. Okay, so that's what bail is. It's just a way to assure that the person has a stake in the events and that they will actually come back. So think about this. Mike Rhodes is arrested for robbery while carrying a possible 25-year sentence. The jail sets bail at $100,000. Rhodes has $12 to his name and no assets. He rides the bus and lives with his parents. He cannot even afford a 10% deposit required to get a loan for it from the bail bondsman. He claims that his rights were violated when the bail was set beyond his ability to pay. So what do you think? Can you set bail? So let's say you don't just outright deny bail. Can you set bail at such a high rate that you know the person will never be able to make as a way to get around the requirement of giving bail? You just set it super high, sort of as a punishment. And the courts have said, no, you really should not do that. Equal protection is violated if you set the bail so beyond a person's ability to actually pay. So if they're indigent and you set millions of dollars of bail, that is going to be a violation of equal protection laws, okay? So they don't want people doing that. So the judge has to decide, are you legit going to get bail? And if so, I have to set it at a reasonable amount. Oh, and that amount is just based on what we think is necessary to get you back to court, something that would hurt enough if you lost it, that you would want to make sure you showed up at court. Or are we going to deny bail? We're just going to deny you bail all the way because of a certain reason. Okay, so you can't use just bail as an end around denying bail. Now, one of the things also that we say is if you require too much bail, it also violates the 8th Amendment. It actually says in the 8th Amendment, no excessive bail. Okay, so excessive bail may not be required. So remember, bail is just to assure that the person is going to show back up to trial, not to inflict punishment. So the bail has to be set no higher than the reasonably calculated to get the person back. So we can't just give an exorbitant amount of money, require an exorbitant amount of bail. It has to be reasonable and enough that it would hurt if you left so that you would not skip out on the trial. Now, what if they want to deny you bail and just keep you in jail? Can they do that? And the answer is yes. So they can just outright say no bail. We're just going to hold you. You have to stay in jail until your trial. There are certain parameters. If they're going to do that, they have to hold what's called a detention hearing. So there are certain parameters that have to be met before the judge is going to before the judge is going to be permitted to just outright deny bail. So they have to have a little hearing just to determine whether or not the person can be eligible for bail. Now, the detention hearing's basic function is to assure whether there's probable cause to detain someone. Now, the only way we're allowed to detain somebody is if we meet one of two requirements. Number one, We can show that if we give the person bail, they will continue to be a threat to the community and dangerous to the community. So therefore, if they are, we can deny bail to keep them out of harming public. Or number two, they're a flight risk, which means no matter how much money we put down, we think they're going to skip town and not show up for the trial. So when we have this detention hearing, these are the only two things we're considering and evaluating to determine if or not we can deny you bail. So no denying bail unless one of these two things is satisfied, that we can say yes to either one of these things. Okay, so there's a little mini trial, a little mini hearing. Each side gets to argue their side, whether there should be bail or there should not be bail. And then the judge would ultimately make the decision on whether or not the person was eligible to receive bail. Okay, so that's your detention hearing. So I just want you to think about some of the decisions that have to be made when determining if a person can get bail or not. So think of this scenario. Carl is charged with attempted rape. He is accused of attacking a woman in his car while driving her home from a bar. He's 22 years old. He's a rookie police officer, but now he's suspended because of the charges. He's living in the city. He's lived in the city his entire life. He has no prior criminal record. So we have to decide, are we going to deny him bail or not? Are we going to release him with bail? And if so, how much? Or are we going to decide whether we should just deny him bail and keep him in jail? So remember, if we deny him bail, we have to satisfy two things. Number one, we have to show that he's a threat to the community. Or number two, we have to show that he's a threat risk. So the judge has to evaluate both of those things and make a decision. The state's going to argue he should be denied bail. He's a threat to the community. He already raped somebody. He was in a power of authority. He abused that power. He could do it again. So they're going to argue bail. A defense attorney is going to say, no, he's not a threat. It just was this one accusation that wasn't even true. We're going to disprove it. There's no threat to the community. It was consensual. So you should give him some bail. Or is he a flight risk? Is there a chance that he could take off? Okay. So the judge would have to balance those two things and come up with an ultimate decision. Now let's think of the second one. Joe is a wealthy businessman. He is accused of killing his mistress. His DNA is everywhere at the scene. So again, we have to evaluate the two things to see if we can deny bail. Number one, is he still a danger to society? Well, he did commit homicide, so that leans towards, yes, you're a danger, but maybe it was specific to his homicides or to his mistress. So maybe he's not a threat to other people. It was just something that happened with this one particular person. So then we can move to the second requirement. Is he a flight risk? Well, he's super, super wealthy. So he could fly anywhere, stay anywhere, live anywhere because he has the financial means to do it. Well, then maybe we can deny bail based on that reason. So that could be the second reason. He could be a flight risk because he has the means and opportunity to avoid justice and hide out. Now, there are some new specific rules that have recently passed in New York that reform bail and when bail can be denied or granted, etc. In New York, if you are charged with either a misdemeanor or what they would classify as a non-violent felony, so some sort of property crime or something like that, it includes stalking, assault without a serious injury, burglary, drug offenses, some arson, some robbery. So if they determine that you are not a threat because it's not a violent felony, or even if it is violent, if it's only a misdemeanor, then in New York, we cannot require any bail. We have to release you on your own recognizance in New York. So no requirement of bail for misdemeanors or non-violent felonies in New York. So it greatly reduces the amount of people that actually have to pay bail in New York. And that's a fairly new change to the New York law. Okay, So those are all the initial stages that have to occur, okay? So the police gather the evidence, and then these initial appearances in front of a judge. Once these initial things are over, then we start moving into what we call the charging stage. Now, remember the prosecutor, and we'll spend some time talking about the prosecutor in it soon. The prosecutor is the one that ultimately gets to decide what the charges are going to be at trial. So sometimes police officers file original charges just to arrest them and get them off the street. The prosecutor has the ultimate decision, which are the charges that are actually going to go towards trial. So they could drop the charges the police gave, they could raise them, they could keep them the same, but the prosecutor is the one that gets to make the charging decision. Now, what are some of the choices that prosecutors get to make? Remember, it's discretionary. Prosecutors have a lot of power because they have a lot of discretionary power. So they could decide to just release the person and not charge them at all. They could evaluate what the police did and they could say, yeah, I don't think that that's enough to charge, and you just let the person go. They could divert the case. So they could send them to a different way to handle it. So drug court, mental health court, counseling, something like that, so that they're not going through the court process. They're kind of diverting them into some other sort of rehabilitative process. Or they can choose to start formal proceedings and actually start moving forward in the steps in the criminal justice system to criminally try them for the crimes that they committed. So remember, that's a choice of the prosecutor. The prosecutor gets that discretionary choice of what to do moving forward. So do you think that what do you think the prosecutor considers when making these choices? So when the prosecutor is evaluating what could happen, these are the things that they're going to decide, if they're going to let them go, if they're going to hold them over, what they're going to do. So the first one that they're going to consider is they're going to look at what's called the strength of the case, okay? So they want to know how much evidence actually exists. If it's a very strong case where the prosecutor has lots of good evidence provided by the investigators, they were able to find lots of things, and the chance of being convicted are pretty high because you have great evidence, that is going to help make the decision. You have to consider whether or not you have witnesses who may or may not be willing to testify. If you don't have a victim who's willing to testify at the trial, it's going to be really, really hard to convict the defendant. So that would be weighing in the decision. Do you have the ability to use the evidence that the police gave you? So you can't blindly close your eyes about the evidence. You have to know how it was gathered. And if it was gathered in violation of the exclusionary rule or any of the procedure rules that we talked about, that evidence could be excluded from trial. So you have to evaluate not only the strength of your case, but what's the chance of all the evidence is usable at trial. You also have to do what's called selective prosecution. Unfortunately, you don't have unlimited time and resources to just prosecute every single case. So you're going to have to pick and choose which cases you think are the most important to move forward on. And sometimes you're going to have to let cases go because you just don't have the time and resources to prosecute them. So they might be more minor things and you just decide to let them go. Okay. So that is selective prosecution. We're actually going to do an activity in here for selective prosecution. So you're going to see how that works and how you can be limited in time and resources, which would affect whether or not you're going to prosecute. I'm sorry, I put something in my mouth. Now, when you're talking about charging, not only does the prosecutor decide whether or not to charge, the prosecutor is also super powerful because the prosecutor gets to decide what level of crime to charge. So the prosecutor looks at what the police officer initially charged, and then the police officer is going to have to decide, do we want to keep those charges or do we want to raise them to misdemeanor, to felony, whatever we want. So the prosecutor has to give that some thought and really think about what is the level of crime that you're ultimately going to charge. depending on which one you decide on, will affect which route you go through the rest of the process. Okay, so if you chose to charge a felony, you have to do one thing. If you choose to charge a misdemeanor, you have to do another thing. So you have to really give it thought and decide which level of crime you want to charge. So let's start with a misdemeanor. So you are brought a case, you evaluate the facts, and you think, okay, I only have enough to convict the person of a misdemeanor. So what happens? Then I, as the prosecutor, get to fill out the charges, and it's called a prosecutorial information. The prosecutorial information is the prosecutor formally writing out the charges that they're going to try the person on at trial. So sometimes you're arrested for one crime, but you're actually prosecuted or tried for a different crime because the prosecutor can change it. If it's a misdemeanor, the prosecutor decides it and writes up the charges and submits them to a judge. So we still need a check on the prosecutor. We still want to make sure there's enough evidence to go forward and that they're not just biased or something like that and pressing charges. So what would be the check on the prosecutor to assure that there is in fact probable cause to charge the person? And that's what we would call the preliminary hearing. So the preliminary hearing is when the prosecutorial information that's submitted to the judge is reviewed by the judge. There's a little mini hearing, and the prosecutor has to put forth some evidence to convince the judge that there is in fact probable cause to continue on to trial. So a lot of times it's sort of a preview to the defendant because the prosecutor has to show their hand. They have to show evidence that they have to convince the judge that there's enough evidence to move forward with these misdemeanor charges. If the judge decides there is enough evidence to move forward to the trial, then that's called binding the defendant over for trial. So putting it all together, the person's arrested and the prosecutor has to decide what to charge. So the prosecutor decides misdemeanor. If they decide misdemeanor, then they complete prosecutorial information. And then the check on that to assure there's enough probable cause is the preliminary hearing. And if the judge decides there is enough probable cause, then they bind the defendant over for trial. Now, what if it's a felony? So we said that is a misdemeanor. Misdemeanor, the prosecutor just gets to write up the charges. But felonies are much, much, much more serious than a misdemeanor. So we want to have a check on this if we're going to charge a felony. So if the prosecutor decides to charge a felony, they have to take the evidence to a grand jury. And the grand jury has to review all the evidence from the prosecutor and make a decision whether or not there's probable cause to continue. So with the prosecutorial information, it was just the judge that made that decision. With a grand jury, it's a group of 23 people that make that decision. Okay, so a grand jury is a group of around 23 people that only listen to the prosecutor. The defense is not there, they're secret, they're quiet. And the prosecutor presents the evidence to this grand jury, there's 23 people, and the majority of them have to say, yes, there is probable cause. You can charge them with a felony. If the grand jury actually decides that there is enough probable cause for the felony to continue, they have to file a certain document with the court. And that document is called the indictment. So the indictment are the formal charges that are for felonies. So when they review all the evidence, they say, yes, there's enough evidence against this person, the grand jury. Then they fill out the paperwork for the indictment. And the indictment then sets forth what the crime is that the person will actually be tried. Okay, that's an indictment. Now, what's the difference between a preliminary hearing and a grand jury? Preliminary hearing, remember, is a public hearing where the defense and the prosecution are both available. There's a judge that presides over it. The judge is going to evaluate it and make sure there's enough probable cause to continue. Both attorneys are there. Both attorneys can cross-examine witnesses. It sort of gives the defense a little preview of what the prosecutor may present at trial. A grand jury, though, is different. A grand jury is secret. It's only the prosecutor. The prosecutor is the only one that presents evidence. The defendant is not there, is not allowed to be there. No lawyers are there, just the prosecutor. And the grand jury has to look at everything that the prosecutor gave them and decide whether there's enough evidence to continue on charging this person with a felony. Okay, so they're very, very different proceedings. One is secret and sealed. The other one is open to the public. One is only the prosecutor, one is both. So there's a lot of differences between them. Most times if the prosecutor wants an indictment, they're going to get it. There's a court case that says that a good prosecutor could indict a ham sandwich. And the idea is that if you are the only one presenting evidence and you're a persuasive arguer, you should be able to get the grand jury to indict. Now, what happens when you're formally charged? So it doesn't matter if it's either the prosecutorial information and preliminary hearing or the grand jury indictment. What happens after? So once you are formally charged, you have to go back to court. You have to have the judge tell you your formal charges now, and that's called the arraignment. So remember, your initial appearance is just what you were charged by the police in the arrest. The arraignment is going to be what your formal charges are. So it's the prosecutorial information or the indictment. That is what you're going to be tried at trial for. So the arraignment, they read you those charges. They're going to tell you specifically what those charges are. And then they're going to ask the defendant to enter what we call a plea. Now, defendants can plea in different ways, okay? They could plead not guilty. So if they plead not guilty, then you just continue on with the steps in the process, okay? And then you just keep moving on. You could plead not guilty by reason of insanity. Again, you're going to move through the process, and the jury is going to ultimately have to make a determination whether or not you are insane. You could have what's called a nolo contendere plea. Sometimes it's called no contest. And what this says, and sometimes they call it an Alford plea. So what this says is we will let you punish us, but we're not going to admit that we did anything wrong. Okay, so we're not going to say we did anything wrong, but we'll accept the punishment that the court's going to give. A lot of courts don't like this because they want the defendant to take responsibility for their actions. So they don't want people making nolo contendere or no contest pleas. Some courts will allow it in certain circumstances. And you can then plead guilty. So if you plead guilty, the steps are done and you go right to sentencing at the very end of the process. During guilty pleas, you have to stand up and tell the judge exactly what you did and how you did it and why you did it, and that you're agreeing to plead guilty without anybody forcing you. That's called the allocution. So if you plead guilty, the judge is going to ask you, is this of your own free will? Did anybody force you or offer you anything to do this? So you're going to have to answer certain questions that the judge asks. And then you're also going to probably have to explain to the judge what you did and how you did it to accept responsibility for your actions. So knowing that, what would your plea be? I killed her, but I did not know right from wrong when I did it. That would be not guilty by reason of insanity. Send me to jail, but I will not actually admit that I killed her. That's your no contest, nolo contendere. I did not kill her. Not guilty. I killed her with a knife because she cheated on me. That is, you're admitting that you're guilty, right? I'm guilty. So not guilty, I did not kill her. I killed her is guilty. Okay. So those are the different forms of pleas that you could have. Okay. Now, I think I'm going to stop here. I'm going to break this into two. Okay. So we're going to take a break. I'll stop it. And then we'll start with pre-trial stages. And then we'll talk about the trial and the sentencing next, because it's just a lot of steps. And in class, I'm going to break it down into two separate lectures. So we're going to stop here. And we'll pick up on the pre-trial stages and the trial and after the trial in the next lecture video. Okay. So I'll see you soon.